Good afternoon, Judge Mothle.
Afternoon, Chief Justice.
Are you well?
I'm fine. Good
I-
afternoon, members of the Commission.
Thank you. Are you relaxed, comfortable, or must I help settle you down?
I'm relaxed. I'm
Thank-
fine. I'd like to think so.
Thank you. Thank you. Um, you, one of those relatively few South African judges who are members of I think you still are, member of the International Organization for Migration. Are you a member of that, together with Justices Scolapen and others?
No, it was an appointment, Chief Justice.
It
to
was an
assist.
appointment.
Yes.
So you
served.
didn't affiliate to the Judges Association that handles migration issues and refugee issues?
No.
Oh, I see. Okay. For how many years have you been a judge now of the High Court?
8 years.
8 years, 3 months to be exact.
Yes. 8 years, 3 months.
And in your own words, why do you believe you're ready for the Supreme Court of Appeal?
Yes, I believe I'm ready for the Supreme Court of Appeal, having gathered experience during the 8 years of my sitting on the bench. And if I have to include also the time I spent when I was acting as judge in the then Transvaal Provincial Division, I believe the experience there and what I gained during my 1-year stint at the Supreme Court of Appeal, it gave me an opportunity to work in an environment where I learned quite a lot from the different colleagues there in terms of how the work is approached of the Supreme Court of Appeal. I believe I'm ready to serve there.
Anything else you want to add? Any experience you have picked up as a judicial officer that has enhanced your suitability for appointment to the SCA?
Well, the experience that I've learned there, an environment which is quite different from the High Court, was the approach towards judgment writing in particular at the SCA. There's a unique process of judgment writing. I must say at the beginning I had some challenges coping with that because I was used to the style of writing that I apply in the High Court, which is modeled along the Constitutional Court judgments. But I found myself having to adapt to that environment. And there were judges to help me do that. And I think it was a worthwhile experience.
Was it a smooth, relatively smooth transition from serving as a High Court judge and then suddenly coming to operate in a different environment in the SCA, or were there challenges? Apart from those you've alluded to.
Well, apart from those, there were really not much problems that I experienced, or many problems I experienced. I had the fortune of being assisted by judges from Gauteng who were there, judges I knew before, and they made my landing soft.
Yes.
And they guided me through the protocols there, the culture, and I really was well received, I must say.
Is there anything about the culture that you found somewhat unacceptable?
The one thing that really not unacceptable, Chief Justice, but that was a bit problematic getting used to, was the immediate conferencing after hearing of argument. Something that we very rarely do in Pretoria. We allow judges to go and reflect on the deliberations, and then when we meet, they are able to give their view before we take a decision or before the scribe produces the first draft. In Bloemfontein, I found that immediately after hearing, before one can even process the deliberations in court, you find yourself already in a conference. But
Yes.
as time went on, I got used to that system.
And apart from that, anything else that should give anybody reason to be concerned, if anything at all?
No, I did not experience anything, Chief Justice, that is
Yes.
of concern.
Is there anything you would want to share with us in relation to the inquest you chaired that you believe could be of relevance to the interview?
Yes, the Timol inquest is the one that I presided over.
Yes.
And the challenge there was that part of the record was missing. For reasons I couldn't understand. The part where the evidence of the police were taken in 1971 and their cross-examination was missing. But the evidence of experts like doctors, Dr. Glackman and everybody else was there. And what helped me understand the proceedings in 1971 was the fact that the statements of the very witnesses were available, they were there. At least I had an idea what they would have said in court. And also, Magistrate de Villiers wrote a very long judgment, fairly detailed, in which he analyzed the evidence of each and every witness, and that gave me some insight into what could have happened. But I came to a different conclusion because, unlike him, I had the benefit of the evidence of detainees who were held with Mr. Timol, and which were not called to testify at that time.
Yes. I know it may be a side issue, but just in the interests of justice and just having regard to the pain that similarly positioned families must be going through, is there anything that you would briefly want to share with us that needs to be done? I know that you wrote your own, let's call it judgment, but anything that you would want to particularly highlight?
Yes, Chief Justice. Towards the end of that hearing of the inquest, the reopened inquest, my clerk received a number of representations from members of the public who came directly requesting that they also be assisted to investigate what happened to their next of kin. And I passed on that information to Dr. Pretorius, SC, who was representing the National Prosecuting Authority. And he told me that there were several reopening inquests that were in the pipeline at that time because investigation had been completed and they were ready to commence with that. And I don't know what happened after that. I was looking forward to the momentum being sustained because people need closure. And that's the sense I got from the representations, that people need closure.
Based on that experience, what would you say seemed to be the reason for taking this long to get to the point where an inquest like that was held? In circumstances where one would have thought, this ought to be a priority, what challenges would you say seem to have given rise to this delay to help people find closure?
From the evidence, mainly by Mr. Kache, who's the nephew of Mr. Timol, he testified in that. He pointed out that there was some reluctance on the part of the NPA in the past when some of the policemen who were implicated were still alive. There was reluctance to investigate that. And he was shown from pillar to post he couldn't understand why there was that reluctance. And I couldn't get any independent evidence as to what would have been the reason. But it was regrettable because had the reopened inquest taken place much earlier, the people who were responsible were still alive and they could have been called to account.
Yes. Thank you, Judge Mothle. I've struggled a bit with the way your surname is spelled. Does the L come where it is, or is it a Home Affairs mistake that you have decided to live with?
I think the last one, Chief Justice, is a Home Affairs thing that occurred many years ago, probably before my time. And I tried to
correct it.
To correct it with the concurrence of members of the family, but some of them were saying, this is it, we're going to, because it's now a big clan of people going by that surname, and it would have taken quite a lot. And,
I see.
And we just decided as a family to leave it as is.
Okay. President Maya?
Thank you, Chief Justice. Good afternoon, Judge Mothle.
Good afternoon,
I
Judge Maya.
think we should first correct something in your application form. At para 16.5, you have answered the question by saying that you have no reserved judgments. And I think we need to, you and I both need to declare that you actually have a reserved judgment. That's a bit old.
Oh, yes.
In the matter of King Tony Mpepu and others.
Yes, when I submitted this form, when I published it, when I finalized it at that time, I didn't have. You recall that that case, we had it on the last day of term.
Yeah.
And by then, I had already prepared this application.
All right.
And that's how we missed out. But yes, we still have that judgment outstanding.
Okay. How has your experience at the SCA been overall, both intellectually and on the personal front?
Intellectually, it has been rewarding, Judge Maya. Rewarding in the sense that, unlike the work rate we have in Pretoria, where for the most part we are sitting in court and we have to write judgments quickly within the given time. The difference I experienced at the SCA is that one gets sufficient time to reflect on the issues and to engage intellectually with other colleagues, those that you are sitting with on the bench. It was a unique experience for me because I've never sat in a situation where I have to be with 4 other judges in court. So that exchange was rewarding for me. And personally, I started off feeling my way around, but I warmed up as time went on. And by the time I left there, I felt that I was part of the team. I was relaxed, and I interacted well with everybody.
I just want to explain the time-honored practice of conferencing directly after hearings in defense of the court. That actually is one of the reasons why the court is able to produce its judgments quickly and efficiently. And the assumption is that because we get our records and the parties' heads of arguments and submissions well in advance of the hearing dates, the judges would have had time to adequately prepare themselves for the hearing. And in the odd case where the matter is that complex, nothing prevents a judge to ask to defer their input until they have had time to reflect. I don't want the commission and everybody in the room to leave thinking that yes, judges are railroaded into giving their decisions.
Yes,
it is not like that.
I take that, Judge Maya. As I said, towards the end of my stint, I had already warmed up to that process. Yeah. And I was part of it. I had accepted it.
All right. Thank you, Judge Mothle. Thank you, Sir.
Thank you, President. Commissioner Mpofu?
Thank you. Good afternoon, Judge.
Afternoon.
Thank you. I was going to ask you about the Timol inquest, but the Chief Justice has covered most of that. But maybe I could just ask you because, I've been approached by one or two of the families that the Chief Justice was talking about. I don't think I'm at liberty to mention their names. And quite frankly, it's quite a daunting task just to think about it, because most of these things have happened as the one you dealt with in the 70s, late 70s or the 80s, and you literally just don't know where to start. What were the challenges related specifically to that question of the age of the problem, if you like? And what kind of advice would you give either to those kinds of families generally or to the government to kind of open up or make a call or some one-stop shop kind of solution to that, given your experiences?
I would say to government, which is something that I of course said to the representative of the NPA, that from that particular case, the fact that a greater part of the record went missing, my fear is that those that may still be held in the future may be met with the same fate. The records as they are now may be available, but unless some measures are taken to arrest that, to make sure that they are preserved, if there are investigations taking place, at least to preserve the records of the previous inquest. And generally, I believe that, as I said, the momentum should have been kept. Because, as I said, a senior member of the NPA told me that there were 2 already inquests that were ready to go. But I'm surprised that 2 years down the line, nothing has happened as yet. And because the investigations were complete, the records were available, but nothing has happened.
Thank you. The next question, maybe on a lighter note, you talked about a soft landing because of the assistance that you got when you got to the SCA.
Yes.
Did the fact that, and I noticed from your CV that you were lucky enough, I actually envy you, to have rubbed shoulders as early as possible with the giants of our profession, like Willie Seriti, Dechang Musenek, and Mos Mavundla, when you did articles there under those people. The irony, of course, is that now when you went to the SCA, one of your mentors, Willie Seriti, was there. So he was no longer going to be able to ask you to do photocopying, as I'm sure he did 40 years ago. But did that, the fact that there was someone who was part of your training and nurturing and growth, contribute in any way to part of the soft landing of kind of navigating your way around that court?
Yes, it did. I worked with Judge Seriti in Pretoria before he was elevated to the SCA. In fact, I came at a time when he was going out. We worked for about a term. After that, he was then elevated to the SCA. So when we got there, he was very proud. I must say, he kept saying to some other colleagues that so far he has produced 3 judges who have made it to the SCA, and one of them is in the Concord. And I was the first article clerk of that firm, and the others followed. Judge Makuka followed, and I don't know who else followed. He has trained quite a few, and he helped with the landing. He gave me advice as to how to approach some of the judgment writing there, and the way in which the court works, because even the terms of the court are different from those in Pretoria. So one had to undergo that change.
Thank you, Chief Justice.
Thank you, Commissioner Mpofu. Minister, with your follow-up?
If you allow me, Chief Justice, as I make my follow-up, I need to declare that the judge was once my boss during the days of Lawyers for Human Rights with Brian Curran. But it's following on the Timor inquest and talking more broadly about matters that arise out of the unenviable past of the dark days of apartheid. You allude to the issue of preservation or disappearance of records, but I also want to just bring the angle of disappearance of witnesses or potential accused, either because of death taking its toll and some of them dying off and dying with the evidence or information that's valuable, not only for purposes of potential criminal prosecutions, but also making it difficult for the missing persons task team at the NPA to bring the pieces together as to what happened to people's next of kin and so on, which is proving to be quite a challenge as a project of the TRC itself. Now, I just wanted to know, based on the experience with the Timor matter when you conducted the inquest, would you find it reasonable to consider various ways of unearthing the truth, including offering a TRC-type amnesty of sorts to some of these people on condition that they give full disclosure, or should we just go full out and see how much evidence we can gather for purposes of prosecution, especially where they haven't come to the TRC and therefore never got amnesty?
Thank you, Minister. I would say both should be pursued. The question of considering some kind of amnesty, even though most of them did not present themselves to the TRC process, including those that emerged in the Timor inquest, the witnesses, and including those that survived now, the policemen that survived. They never presented themselves to the TRC process. And towards the end, I make the point, correctly so, that evidence will disappear, memories would fade, and we'd have a situation where people are left without closure as to what transpired. I'm mindful of the fact that when the whole democracy process started, there were negotiations where undertakings were made about sunset clauses and so on. But these were corrected through the TRC, that people must come and make available whatever information they have through the TRC process. That could have assisted, but at the end of the TRC, certain recommendations were made which were not followed. And one of the witnesses pointed that out, to say that some recommendations were made where people did not present themselves, but there was no, one witness said, willingness to follow up that. But I believe that if some kind of amnesty could be provided, it might be a shorter way of getting to the truth than through a protracted inquest that may not yield much. That's my personal view.
Thank you, Chief Justice.
Thank you, Minister. Your follow-up again, Commissioner Mpofu.
Thank you. I'm so sorry, CJ, for the indulgence. Yes. Just one thing that I forgot, Justice Mothle. Part of your CV shows that at some stage you were an advisor to the Premier in Limpopo.
Limpopo, yes.
Yes, and advising the ANC and how to set up the new government.
Yes.
Now, that obviously you were working there, but it could be seen as a semi-political role or appointment. Has that role ever impeded your independence to give judgments, in terms of according to your conscience, or did you ever feel that you have to please your previous masters?
No, it never happened. Our role there was not political advice. It was legal advice. What happened was there were 3 homelands, and plus the Transvaal Provincial Administration in the whole of what is now Limpopo. And they had to be collapsed into one administration. And the difficulty is that each one of these institutions had passed certain laws, and budgets have been given in terms of those laws. And hospitals were built and so on. And in one instance, I remember, there were 2 hospitals that were less than 1 kilometer apart, the one in Gazankulu and the other one in Leboa. So we had to come up with a kind of legislation that will ensure that the disruptions do not take place on the ground, but one act that will apply the whole province. So rationalization of that legislation was our main task, not much political advice.
Thank you so much, CJ. Thank you.
No, thank you so much. It may look like we're spending a lot of time on something that is not directly relevant to testing your suitability for this position, but it really is relevant. I never really got to appreciate how deeply the pain of not having found closure cuts until I was asked by the Kalata family to come and address a meeting directly related to Fort Kalata's death. And it became so painful because they gave me a book written by the son, Lukanyo Kalata, which explains circumstances under which the father died while he was about 8 years old. His younger sister was not even given birth to yet. And when you read his explanation in relation to attempts made to have this matter opened up and looked into, the strong language he uses there tells you just how much pain, his heart and his mother's are soaked in. What is it is there anything that you could do in your private capacity, so to speak, to encourage or advise or guide government or whoever else in relation to what could be done to really do something about this, however difficult and near impossible it might be to them to do something about it, with the experience that you have had? Because the pain really is inexplicable. It defies words.
I agree, Chief Justice. As I said, I had a situation where when I presided and listened to those witnesses relating their experiences under Section 6 of Terrorism Act, it was very difficult. And I would have thought that by now, whatever is obstructing the holding of these inquests would have been addressed by those in government, because that is where it lies. The inquests can be held, investigations must be made. In some instances, there may not be closure, but in other instances, at least the truth will come out as to what happened. But I'm unable to say what is holding the NPA from coming up with these inquests. I made that recommendation towards the end of my report or judgment, as it were, that they must be held. And I don't know why they are not held.
The little understanding that I picked up is that resources largely explain why it has not been found possible to go there, given the age of the incidents. But is it something that you're willing to look into and without being overly committal? Is it something that you're willing to agonize over more and see how best you can suggest what to do to the powers that be?
Yes, I could look into it, Chief Justice. Since that experience, I've lived with that problem of what happened to those that came through to me and they needed closure.
Yes.
In one instance, an old man who said he last saw his son being detained. I later learned that the old man passed on without closure. And it's a difficult process, but I think government should make an effort. I'm not sure that the question of availability of resources could be the one that would stop this. I think it should start. As I said, I got an assurance from a member of the NPA saying that 2 of these are ready to kick off. The evidence is there, the witnesses are there, investigations have been completed. But up to now, I don't know what held them back.
Commissioner Nyambi?
Thanks, CJ. Afternoon, Judge Mothle.
Afternoon, Commissioner.
I must credit you for being part of the lawyers that campaigned for the abolition of the death penalty and assisted prisoners on the death row to exhaust their available remedies. Now, it has become a football, the issue of death penalty in South Africa. There are people that are saying we must have it back. What will be your advice out of that experience?
My advice is, I understand the frustration that people are having with the levels of violence. Some calling for the reinstatement of the death penalty. But we argued then, and I would argue now, that there were instances where, as we assisted people on the death row, we found that they were wrongly convicted. And in the case of one person, he had already been given notice to be hanged. They normally gave 7 days notice. When we intervened with an urgent application, we stopped it. And when the appeal, he had not exhausted the appeals because he didn't have funds. When we got advocates to go and make a representation and put on the appeal on the record, the appeal court found that the man was innocent. And that intervention, if anything, convinced me that it is very, very dangerous to rush to execute people, because it may happen that the truth may come out, and it's too late to can reverse the situation. But on the other hand, I understand the levels of violence in the country. They cry out that among us there are people who go just wantonly killing, taking life, and they seem not to be deterred by the life sentences that we hand down. It's a complex issue. I myself have sentenced quite a number of people for life, and in instances such as those. I did not hesitate to do it, but I'm not sure whether I will impose a death penalty.
Thank you. My last question. What is your view of the role of traditional courts in creating access to justice?
The question of traditional courts is still on discussion. Their role has to be located within the administration of justice in the country. They have jurisdiction in terms of the areas in which they operate, those traditional courts. The one advantage about them is that they would invariably not impose a custodial sentence. They will come with a different kind of punishment that will ensure that the breadwinner still remains to take care of the family. That's the one advantage of those courts. But the kind of punishments they give have to be controlled because, as we are aware, it can go way out of line where people get assaulted and they get killed in the course of imposing that. So it needs to be controlled. I think it needs to be controlled to bring it in line with the administration of justice in the country, the way the courts are administering now.
Thank you, Judge Mothle. Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
In the judgment that you wrote, the Masamula judgment,
Yes.
I think what you reveal there mostly and largely, other than the legal aspects to it, are your emotions.
Yes.
I don't know how many times you've used the word sympathy in that judgment.
Yes.
Could you just tell the Commission briefly as to why it pained you so much to perhaps pen it and give the outcome that it ultimately gave in the end? Thanks.
Yes. Let me start by saying that it was a collective feeling of the bench. All of us, I was the scribe, but all of us felt that way. When the evidence shown that he was a 90-year-old person who had undergone all these operations and who had a history of contribution that he made to this democracy, to the struggle in South Africa, and eventually to this democracy. Mr. Masamula is a person who's well known in Limpopo, and he's well known to have made a contribution in many ways, especially to the African National Congress, but most importantly, to the struggle for liberation in this country. And that's what evoked our emotion collectively, that we felt if there was a way in which he could be assisted, that there should be that assistance. But we could not find any other way to help, to be of assistance.
Yes, thank you.
Yes.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Didiza?
Thank you very much, Chief Justice, and good afternoon, Judge.
Good afternoon.
I want to take you back on an issue that you raised with regards to how you were taken aback about the manner in which the SCA operates, particularly in having to have conference immediately after the sitting. I know you said you finally got used to it, and I've heard the rationale for that from Judge Meyer. But if I were to ask you, from your experience and anybody who's acting for the first time in the SCA, how would those who are first-time actors in that position be prepared so that they can better understand and assimilate into that system?
I would think that, as I did when I went back, my stint was from December 2017 until end of November 2018. So I went back to Pretoria, and this last term I've been in Pretoria, and we had appeals. I sat on appeals, and I used that method. I believe that if we could have some kind of uniform approach to dealing with that, I used that method, and it worked well. Well, we were not 5, it was a 2-bench appeal. And we were able to discuss immediately after coming out. I told them how the SCA approaches it. And I wanted to see whether in that setting it can work. Because if it does work, then it's something I would recommend to the Judge President, so that then those who have to be called to act get there already being familiar with the system, at least that part of it. And I tried it, and I think it worked well, because there was no problem. As Judge Meyer correctly said, we receive the appeal files long before the date of hearing. We read and we prepare So when counsel come to argue, barring some exception, normally you would know already what the issues are and what each party's stance is. So as you come out of there, as a judge, you already more or less have a prima facie view of where you think you will go in terms of if we were to make a ruling. So it wasn't really a big problem. It's just that I found it operating in a situation where I had to sit with 4 other judges. And I was still undergoing that shock experience of working with 4 other judges. And especially if you are the scribe, you have to try and bring all other 4 judges to see things your way. And those are the challenges I never had before.
Thank you, CJ.
Thank you, Commissioner Didiza. Commissioner Kane.
Thank you, Chief Justice. Good afternoon, Judge Mothle.
Good afternoon, Commissioner.
I would like to engage with you about a judgment in a tax matter, Sasol Oil versus SARS, in which you wrote a dissenting judgment delivered on 9 November 2018. So it should still be fairly fresh in your memory.
Yes.
In essence, the majority of the court held that the transactions were genuine transactions, whereas you took the view that they were a sham, and you were confronted by strong majority judgments, 2 of them. It seems to me that your findings were largely based on the credibility findings of the court are quo, and there the majority held that it was unclear why the tax court had rejected the witnesses' evidence because there was no evidence to gainsay what they'd said. There was no motive to lie, and they found that the tax court's findings had been somewhat disquieting. Now, my question is whether you would please explain why it is that you dissented. I should also bring to your attention the fact that the Constitutional Court has rejected leave to appeal in this case brought by the Commissioner on the basis that it didn't engage the Constitutional Court's jurisdiction and that there were no prospects of success. It seems to have been a brave dissent against a strong majority and found to have been an incorrect dissent given the Constitutional Court's findings. May I ask you what experience you have in dealing with these kinds of matters and what caused you to dissent?
Yes, I've dealt with tax matters in Gauteng. Not many, but sufficient to give me an idea as to how it operates. The basis on which I dissented, and it was 3-2. It was not the majority, overwhelming majority, it was 3-2. One of the members of the court supported my dissent. He concurred with my dissent. So it was 3-2. And in fact, when we discussed the matter after hearing the arguments, there were other members of the majority who were still not sure which way they want to go. What was at the center there was not only the evidence that the witnesses gave, there was documentary evidence. And that is, if you see my judgment there, I'm basing mostly on documentary evidence. The documentary evidence that pointed out that it was a sham. The interposing of that company was a sham. And I still hold that view.
In order to have found for the Commissioner in the case, you would have, in addition to having found that the transactions were a sham, had to have dealt with the attribution of the income in terms of Section 9D of the Income Tax Act.
Yes.
And I don't see any reasoning in your minority judgment on that element. Was it an oversight, or is there a reason why you didn't deal with that element of the liability of the taxpayer?
The question of 9D, we were not differing on the question of 9D. We're differing on the evidence that was there. I felt, and I said to the majority, that they were overlooking the evidence, documentary evidence that was there. And it is in my dissenting judgment.
Thank you, Chief Justice.
Thank you so much, Commissioner Kane. President Meyer?
Thanks for allowing me a second bite, Chief Justice. I'm sorry, Judge Mothle, I forgot to ask you two tiny questions relating to information that's in your application form. You listed medical conditions from which you suffer, which you say are under treatment. Are they under control? And is there any chance that they may interfere with the conduct of your judicial function?
No, they're under control. I was diagnosed in 1996, and to this day, I'm still taking treatment. They're under control.
And you are able to work hard, as I can attest.
Yes.
Yeah. I also wanted to commend you for being a member of the International Association of Women Judges. That shows a feminist streak in your part, on your part. But
Yes.
can you just explain to me what the Judges Association of South Africa is? Because I don't know it.
The Judges Association was founded by mainly Pretoria judges, and its objectives are similar to the chapter of the International Women Judges, except that it accommodates everybody else. We felt we needed a platform where we could, as judges, interact on a number of issues that were not within the powers of the heads of court, for example. Our exchange with judges who are appointed to work overseas, we wanted to benchmark. We felt we needed to benchmark our contributions and our performance here against the best practices. When I started off in Pretoria, we had 3 delegations of judges coming from different countries. And they shared with us their experience, and we found that rewarding. And they also invited us to come through, that we should consider sending delegations there so that this exchange should enrich us as judges. And we raised it with Judge Mlambo, but the response we got was that there may not be the budget to do that on an annual basis. And so we felt as judges that we need to come together and on our own steam, because it will benefit us, set up, amongst others, an organization that will assist in organizing these exchange trips. Secondly, we felt that the judges' views are not being heard where things matter. It was not surprising, for example, that women's judges had to stand up and articulate collectively their view in regard to how women are treated in this country. That's the reason why I subscribe to that organization, because it's the same objective that we had in the Judges Association.
Thank you, Chief Justice.
I've wondered for a long time what that association is about, and I think it's important that we touch on it. At some point, I got a sense that it was born out of a dissatisfaction with either the willingness or the capacity of the head of the court to represent the concerns of the judges properly. Was I mistaken in thinking so?
Yes, you were mistaken, Chief Justice. It was not out of any issue that concerned us. When we set it up, it was, amongst others, to look at, to discuss issues that would find their way to the heads of court.
Yes.
Through our judge president, because we felt that we needed a platform where we could discuss issues that we feel we may contribute to the deliberations in the heads of court.
I say it because at some stage he sent a document that members of that association had prepared for the heads of court, and colleagues and I were very categorical. We said, look, we will never allow anything that has even the unintended consequence of undermining the authority of a duly appointed head of court.
Yes.
We said to him, go and speak to your judges. You are their leaders. Let them tell you what their concerns are, and let it be you as their leader who conveys their views to us. We are never going to have a parallel structure. Judges speaking with this voice as if there is no leader. If you are incompetent, we said to him, let us know so that you can, a way must be found for you to be removed. But we can't have a situation where there is a trade union-like operation at a court level. So you are assuring me that there is nothing trade union-like
No, there's nothing trade
about that
union-like.
association.
Chief Justice, I can assure you.
And we'll never have a situation where we are expected to entertain representations from judges as if there is no channel in the form of a judge president through which those concerns can be conveyed to either me or the heads of courts together.
Well, there was one incident, I must mention this, Chief Justice, where we were invited, I think, by Judge Wegley, when the issues of the salaries of judges was discussed.
Yes.
Yes, and we prepared a document to that effect as a contribution to that discussion. And that's how we made a representation.
Yes.
Because we took it that he's representing the heads of court as head of the Committee on Finance.
Yes.
And therefore that he had a mandate to communicate with all the judges.
Yes.
So we collectively prepared a document to send to him.
Yes. No,
And
that.
it wasn't,
Yes.
we did not deem it fit at that time to say it must first go through the judge president to the heads of court before it reaches Judge Wegley.
Yes.
We may be wrong with the procedure, but we
Yes.
thought he was inviting us to make representation.
Yes, you were wrong, but you didn't mean to undermine the authority of the
No,
judge
no,
president.
no, we can never do that.
No, thank you so much. Commissioner Singh?
Thank you very much, Chief Justice. Good afternoon, Judge Mothle.
Afternoon.
I was not going to ask any questions, Chief Justice, but I've been prompted by people who read the Daily Maverick and read words such as political football that have been used. So I thought I need to just ask the Honorable Judge a question. Good afternoon, Judge.
Afternoon.
Firstly, I want to compliment you for the role that you and other comrades played pre-1994 in looking at the abolishment of the death penalty. I think it was a very good and wise thing to do, so I want to compliment you on that. When asked a question by another commissioner, you did say that this is a complex issue as we sit in South Africa now.
Yes.
There are 57 reported murders a day, and it's getting alarmingly frightening that many young people, young children, and women are being murdered. Now, the feeling amongst some of our constituents is that the punishment that's being meted out to the perpetrators of these crimes who have been found guilty does not meet the severity of the crime. And is it not time that we talk about harsher sentences to be imposed? Should we not have a debate on whether or not we should be looking for other measures to assist the judiciary and the public at large to realize and appreciate that we can go this far and no further in terms of the number of murders that are taking place? Earlier on, another colleague of yours said that in response to this kind of question that, you know, it's getting out of hand and people get away scot-free. And the reason he gave for that was, amongst other things, the lack of proper investigation and the lack of capable and suitable prosecutors. Now, what I'd like to ask you, Honorable Judge, in the circumstances that we find ourselves in South Africa now, with these alarming statistics, is there any harm in calling for a discourse on harsher sentences, which may include, not shall include, which may include capital punishment. Is there any harm in calling for such debate? Because that's exactly what some people are calling for. They have not pronounced themselves on whether they prefer the introduction of capital punishment or not. So I just want to ask you what your view is. Thank you.
Well, Commissioner, saying there's no harm in having a debate on, I guess, anything that is of concern to the country. But I need to point out that in having that debate, you will find, as you go in, that there have been studies made about the various modes of punishments, that amongst others, even in countries where the death penalty is still operative, crimes are still being committed. It hasn't succeeded to deter criminals from committing crimes. So the discourse should be there, it must be there, in order to enhance and answer the question, why do we have so much violence? And also among the judges, for what it's worth, through our leadership in the judiciary, we'll make our contribution as to what our experience is in terms of how effective are the sentences that are given. One of the cases I've included in my application relates to an attempted rape in Eastern Cape, where a sentence of 6 years, half of which was suspended, if I recall well, was imposed on attempted rape of a minor. And it's a, I think it's a human issue, The sentences are there, but different judges will impose sentences differently. There are judges who are known to be firm with their sentences. And there are others who are known to be sort of not that firm. But collectively, all I'm saying is that throughout the whole administration of justice, the discourse has to take place in order to find answers. How can we curb the incidents of violence? And they're not only located in administration of justice. Some of them have to do with the social arrangements we have in the country, the economic arrangements we have in the country, where people are unemployed, there's poverty around, and so on. So it's a deep discussion that is needed. But yes, a discourse will assist. It will help ventilate the issues.
Thank you, Justice. You've answered the question. And I think you've given sufficient reason for continued discourse. And I might say you kicked for touch, but that's good. We still need to have the discourse. The football's kicked for touch. It's playing rugby now.
Thank you,
Justice.
Commissioner Singh. Thank you. Commissioner Norman.
Thank you very much, Chief Justice. Just to follow up, Judge, the question that was posed by my fellow Commissioner Kane was that here you were faced with a judgment by there were strong judges, and then you dissented. But I just want to find out from you, is that how you are supposed to approach judgments? If you want to dissent, you look at who's strong, who's not strong. Must I dissent? Is that really a way that you are supposed to look at as a judge?
No, absolutely not,
Yes.
Commissioner Norman. I dissented because we independently read the documents. I formed a view. We went to court, and I was not persuaded from the view I held. And incidentally, as I said, one of the senior judges who were in that panel, who formed the majority, was uncertain. And he asked me to write my dissent. He wanted to see how I'm approaching this. He was uncertain. It was an issue that is complex. All of them admitted, including the scribe, Judge Lewis. She pointed out that this is a very difficult. She's been sitting on a number of cases of text. In fact, in the judgment, I quote one of her judgments that she wrote before on the similar subject. It was a complex thing, but I was guided by the evidence that was there. And I said, on the basis of this evidence, this is my view. And I would dissent against anyone.
Yes,
I
and-
wouldn't have a problem.
Thank you. And do you yourself regard yourself as a strong judge?
Yes, I do.
Yes, thank
Most
you.
certainly.
Thank you, Chief Justice.
I laughed because a colleague wrote the judgment, the dissent recently, and said, 3 of our esteemed colleagues have written. I said, no, we are all esteemed. You're excused, sir.
Okay, thank you. Thank you, Chief Justice, and thank you, members of the Commission.